Hello, everyone. This is Ivan C. I have been providing legal services in residential and commercial real estate, corporate and commercial transactions, and wills and estates law for over 25 years. Whether you're a home buyer or seller, lender or borrower, developer or investor, parent or child, strata dispute or real estate litigant, real estate agent or managing broker, our real estate clients have come to expect top-rate legal advice and assistance in structuring the transaction to suit their needs for advocating or enforcing their legal rights. Subscribe to my YouTube channel for the latest news and information. We look forward to working for you and are confident we will meet your highest expectations. Includes things such as what to look for when you're helping a client go through a lease, if they have to do that. But also at the end of the time, when you have a commercial building and the suggestion is whether or not you want to go through the regular transaction of buying the land or buying the shares of the company that owns the land. So that's another way of doing the purchase. And it's not as common, but it's a very beneficial thing for you guys to know as an option to do the purchase and structure the transaction. So I have a couple of things. So this is my contact. Some of you got worked with me already, and some of you have reached out. So a couple of things. My cell phone's over here. You text me. You say, "I'm a One Collective realtor. I have an issue. Is there something I can help? If there's something quickly that I can help you with, I'll help you with that and get the deal moving on. If I need more time, if you need to have more extensive consultation, then I'll let you guys know. But I'm always open for that. And some of you have worked with me and know that already. Okay." But besides real estate, I do business and corporate. So when it comes to share purchases of land transactions, I can help, and I know all the ins and outs about that as well. And wills and estates planning, I do. If you guys have holding companies with clients with holding companies, and they want to pass on assets to the next generation, transfer real estate to the next generation, there's more than one way to do it through companies and wills and estate planning. Okay. So a couple of things I want to start up with common commercial transaction scenarios. A couple of them. Business asset purchase. You're just buying the assets of the business. Or you buy the shares of a company that runs a business in order to operate the business. Or you purchase a franchise, you along with perhaps with the company, another shareholder purchase, but you're being a franchisee when you're helping a client. You may even have clients who are franchisors looking for franchisees. Actually, this weekend is a national franchise convention happening, so people are all there looking to buy. If you know how to help commercial clients, this is a good time to go get a lot of franchise businesses and commercial clients. Another one, commercial land purchase, just buy the land itself with the buildings, and sometimes there's strata offices, and sometimes it's like a whole bunch of malls with a lot of retail shops. That's another type of transaction. Commercial land purchase of shares as well. So you can buy like one of the transactions we worked on was the Semiahoo Mall. So you have like 30 or 40 tenants. So you got to do leases for all the tenants, and you got to do the land and the development. So that's another thing. Sale of land with commercial tenants. So buying the land versus share or land purchase, but needing to deal with existing tenants. So there's a lot of issues dealing with that. Okay, so these are just a snapshot of certain scenarios. Now, things to look out for and things that often, when it comes to a commercial deal, which is not often done with enough without catches a lot of agents and buyers and sellers alike by surprise, is not really making sure that the lease is appropriate for the tenant or for the landlord to know what they can do if the tenant is not working out as well in the future. But here are 19 different things. And if you guys, first of all, maybe a show of hands, who does commercial deals here? Yeah, you do some. Okay, looked at a lease. I swear, I thought you had a mask. I didn't know it was you. So, okay. Anyways, everybody looks the same, the black hair and all. Okay. Anyway, so 19 different things. These 19 items are not from the most important to the least, but they're very important things to be aware of, to look for, and be knowing what they are, what they do, and what the importance of having those terms. So, first of all, does the existing lease allow for an assignment of the lease? Know that I've had a situation one time. I had a seller client that had a restaurant. It was a sushi restaurant. Kept on It was near the end of the lease. He wanted to retire, wanted to do business. He had new buyers coming in all the time. And the landlord kept rejecting, kept rejecting, kept rejecting. That the lease was ending its termination point. And when you have a business that can operate and you can sell it as a business, it's worth more than when the lease is over and then the landlord can just say, hey, your lease is over. There's nothing to assign. So the idea is like make sure that there is a way for if you have a client who's selling, it is able to sell, and which means to assign it to a new buyer. Some leases have a little provision saying the landlord have ultimate power, control, and discretion as to whoever comes. They can say no. No, I don't like the way they look. I don't like the way they are. I don't like the ethnic nationality. They can have ultimate discretion. So you have to be careful to look to see what are the terms that allows your client who's selling to sell. If you have a buying client, a client who's buying, then they have all this. We talk about strategies later to increase your potential tenant, potential buyer of a business, increase their chances of being accepted by the landlord. But it's the very important first thing is to read the lease to see what are the terms of the assignment. So what are the conditions? Maybe they ask for good credit. Maybe they ask for experience in the business. They want to check is it in the complete and utter sole discretion of the landlord? Consent not to be, this is a very important phrase. It's very common to find, but if you don't see it, the likelihood is that the landlord has total discretion. You want to have something there that says consent not to be unreasonably denied. That one client, it turns out that the text from the buying agent to the listing agent, there was a text. The landlord is tired of, I won't say who and which, but the guy was very against anyone who's East Indian descent. You can tell it. They're not allowed to discriminate, but we found that little text in order to find out why the landlord was kept rejecting all these good applicants. Anyways, I just want to put that there. History of bias, because you can ask them, what kinds of things that this landlord has chosen in terms of who they wanted to be the tenant before. Very important, because if you have a client that wants to buy and the landlord is totally unprofessional or unreasonable, it's tough for you to sell. And the same thing, if you have a client that wants to buy a business, it's also very tough. Okay. Another thing, Another thing which is very, very common to have a problem, subjects are removed, there's going to complete to satisfaction, but the landlord says that, hey, by the way, the existing seller, the one who wants to leave and sell the business, is not released from the lease. Now, what that means is that the buyer takes over the business, the seller leaves and thinks that they've gone with this business, but the new buyer has problems. They don't pay the rent. They can't do the business as good as the one who sold. And then the landlord can now go chase after the original owner to pay for what's due, pay for what wasn't paid, and compel them to almost like guarantee the new buyer. And that's very common. You have to look at the lease to see whether or not the landlord has that ability or right to release the existing tenant. Okay, that's very important. And so often it leads to dispute. Like you start, subjects are removed because they think about financing. They think about checking about the sellers. You have a buyer client. They're checking the history. They're checking the financial statements. They check everything except what they didn't check was the landlord was not letting the seller leave. Right? Keep completely free, and then that's a deal breaker. So oftentimes it leads to a whole bunch of problems. Of course, when and if you ever get to that situation, there's strategies of how to deal with it, how to take care of it, how to reduce and minimize the risk if you have a tenant who's leaving and wants to minimize the risk when he leaves. Okay. And then there's other ways we'll talk about how to do that. Okay. Now, another one, who pays for the landlord's costs? Quite often there's a term somewhere, someplace that the landlord has, their fees has to be paid. And, in a situation which is common, you have a tenant, a potential tenant, buying it from an existing seller, and the landlord conducts certain searches, such as credit searches, and does criminal record searches, does court search, and I'll talk about due diligence later, and bills it and charges the existing tenant all the costs to find out whether or not the new tenant can be a new tenant or not. and then all of a sudden there's a huge bill that comes in. There's a dispute between buyer and seller. You want to avoid that. Make sure that there's some certainty and clarity. If it's unclear, put it in your contract. The buyer and seller agree to split the fees of the landlord. Anything dealing with the new assignee, the buyer, the buyer pays. Anything dealing with the seller pays, or split the fees as much as you can. Have something certainty there. Leads to all kinds of arguments. How does a security deposit held by a landlord get assigned? Now, imagine this scenario where there's a lot of money being held by the landlord. Now, they have normally, in most of these leases, the landlord controls. Do they give it back to the tenant who's leaving, or they keep it? And then the buying one has to give money back to the selling tenant. It's good, important to know these things, to know how the security deposit is being dealt with. But usually, it doesn't matter what the buyer and seller agree upon. It's the landlord that decides. Okay. Okay. Another item: how is price allocated? Now, this is something very different between residential versus commercial. Commercial, you have to decide how much of the purchase price is allocated to the equipment, how much is allocated to the goodwill of the business, and how much is allocated towards leasehold improvements. There's consequences for each one of these items, how you divide it. Um, uh, so, anyways, it's important to know that and have that discussion. Now, for those that may have, oh yeah, you have a question, and of course, you guys have questions as I talk about a topic, and it comes up. Don't hesitate just to ask. So, Crystal, you have a question? Yeah, yeah.
Ultimately decided by the client's accountant, I'll say.
Very common. Now, the reason why this happens, and I usually say it's the seller's accountant, because they're more sensitive about how much that their book value for the equipment is. So every year they buy the equipment, they depreciate the value of the equipment. So if they sell the equipment that's worth more than what the book value is according to their accountant, they have to pay capital gains on that. So there's tax on that part. Now the buyer, they're concerned, they're thinking about, well, they have to pay GST on top of the equipment price, or the PST on top of the purchase price. That's 7%. So sometimes they want to save on the 7% tax. The seller wants to make sure they don't pay capital gains. But quite often in this situation, if there's neither or, it's usually the seller that decides. But it should be something that's discussed. If the buyer, no, hey, no, buyer, if you're buying it and you put too much value to the equipment, you're going to pay a lot of tax, 7%. You only 5% GST is also on total purchase price of the business, but 7% on top on the equipment. Okay, so that's something, an extra tax component. Sorry. Yeah, yeah, sure. Go ahead. Yeah. Sorry, what's your name again?
My name's Thomas.
Thomas.
Two.
Yeah.
One is what constitutes as reasonability.
Yeah. What's reasonable? Yes.
It's always a debate, right?
Oh yeah. Oh yes, definitely.
And then the second one is um, why would the landlord willingly give up the release of the assignment?
Where was that? What section? What was that? Release. Was it here?
Oh, yeah.
Landlord, yeah. Right here, right? This one here? This one. So what's the question again? Sorry. What constitutes reasonable? Okay. Yeah.
The second one is why would the landlord willingly consent to a release of the assignment?
Yeah. So I'll start with the second question first, and it ties in with one of my segments later on. It's like you represent the seller. Or you represent the buyer who wants to buy a business. So normally what I tell a buyer is how to alleviate the landlord's fears and concerns, how to make it better for them to accept something like that. So one thing is for the buyer to come in to give a higher deposit. So if the landlord is usually concerned about who the buyer is. Will they do a business successful? Will they be paying on time? Do they have enough experience? They do a credit search. If it's pretty good, okay, less concerned. If it's so-so, more concerned. They look at their background. So when I represent buying clients who are anticipating a landlord's discretion, I said, do a credit search first. And if it's not good, so-so, it could lead the landlord to have some problems with it. get a second guarantor to be the guarantor to that lease, so that they have two people, maybe a lease with better credit, and then offer a higher amount of deposit. And then if they can, ask and negotiate with the landlord. If after 2 years, for example, the clients are paying on time, then in the contract of lease itself, it allows for the release of the higher amount of deposit. The more and more the landlord becomes comfortable with the tenant. So so the landlord may say, "Well, I don't know who the buyer is. I don't know them. I'm not gonna release you unless they get something in their hand on the other side." So they got higher deposit. It goes high as you need to. And I tell my clients, look, up front, but you may be able to get it back if you can negotiate it well. So I just try to anybody who's selling the business, try to do everything possible to not be liable after the purchase, after the sale, and try not to be personally liable as well. But if you can do those type of things. Yeah. Okay. So when it comes to what is unreasonably denied, so it's all in context. So if it's a very, for example, I have a situation where I had a client who was getting um, let's just let's say a certain area that had Vietnamese food, and the other one was selling noodles mostly. The other one sold banh mi's. So they don't really conflict because they're two different types of food within the same kind. But then the restaurant that sold the noodles started selling banh mi's on the side. And then that's going to be competing with the interests of the other ones, because depending on what percentage of the business, those are types of considerations. So it's all contact specific. All kinds of situation. Now in the neighborhood, I had a Fraser Street client. The landlord was very unreasonable because what he was concerned about was noise. Now, exhaust fans from kitchens blowing all the time because he had tenants upstairs, so he was complaining all the time about the noise, complaining all the time. So you have residential neighborhood by a commercial tenant. Then you say, look, the landlord's concerned about the noise. So what type of business will come in that may or not cause a lot of noise problems? So now it can't be arbitrary. It can't be like the one where we caught the person saying, but he's using other reasons to say it, but he really didn't like a certain ethnic group, and it wasn't coming out. No matter how good the credit is, no matter how good experience it is, and they just kept getting rejected. It wasn't a money thing. It wasn't a business experience thing. And we found out it was something related to that. And eventually, we found another Japanese client that was going to run another sushi restaurant. We finally got it through, but they kept giving other excuses for it. But you can't use things that are against public interest, discrimination, human rights type of things. But anyways, all context specific. Yeah, and then sometimes it is important to look at the neighborhood, look at the landlord, look at the nature of the business to kind of guess what it is that would make the landlord be happy, right? If you're representing a buyer client, or if you're actually representing a client who's trying to sell, what would allow that to happen better? Okay. That's good. Move on. Okay, thank you. Where were we? Special consideration. So yeah, so I was talking about competing businesses. Some landlords doesn't want to have even the potential of having competing tenants inside a strip mall, for example. So ways to make it more objective sometimes is to agree, and I have clients that do this right in the lease itself. They had to put a section that the menu items being offered will not compete with the other competing business. No more than 10% of the price or sales or items being sold will not be of a something that would conflict with another one. So you have a bakery that sometimes offer coffee on the side, or a coffee shop that offers a little bit of bakery items. But then how to be objective to make it, you make it very specific as to how and what percentage of what they can do and what they can sell so they don't compete. Unwanted businesses, so like the idea about noise. I have a client that wanted to, close to a school, they wanted to open a business that made like a vaping. So the landlord just didn't want to have anything like that close to a school. And then hours of operation, when you have clients who are in a mall, they're very strict. If you don't open for 1 or 2 days, you might be violating the lease. Those are very strict in terms of hours. So they want to have uniformity across all the tenants. So there's different types of things to think about when it comes to whether your client is able to meet those types of special requirements. Okay. These are all things to think about. Now, What things, if you have a potential buyer, what things to check, what things to look at before you commit to actually buying it? Maybe you have subject removals. So there's all types of things you can look at. Anybody know what a PPSA is? Anyone here? No? So when you have your most residential real estate, you're mostly concerned with looking at title and looking at the registered charges, financial, non-financial. But companies and businesses, they have something called the Personal Property Security Act registration, which is a lien on the equipment of the business being used. A good example is many coffee shops have their espresso machines on payment plan. So if you buy a coffee shop and then you think you're buying all the equipment, but then you realize, oh, there's a lien placed against the equipment that they're still paying the bank. And then you take over and you think you got it, but then the payments don't get made, and then they can seize the property back because the lender didn't get paid for it. No, these are things. So GST, of course, you can check to see if the GST is paid or not paid up. Social service tax is 7%, fire department, city bylaws. These are all things to check. I had a client that had a restaurant, and a client that was buying a restaurant. And when they did the search with the fire department, no, the city bylaws, there's actually health department that there was an just like how residential homes you may have things like orders from the city saying, "Oh, you gotta to make the house a little further away from the sidewalk," and all these types of orders, or maybe an unauthorized addition was on a house. They have these things with companies as well and businesses, so it's good to check them all out. One time, the client was supposed to have put a washed hand basin separate from the rest of washing the food and cleaning hands for preparing food versus cleaning hands period. They need to have a separate bathroom and separate wash basins. You don't know these things until you check. Employment standards, see if someone was fired, someone sued them for unpaid wages and things like that. Technical safety, BC, anybody know what this is? You have right now, like if people are selling, if you have a client buying an apartment building and they have a central heating, insulation, and boiler rooms, and they have elevators going up. These are things to check whether they're compliance with the maintenance of these equipment. Okay. And then, of course, you're more familiar with these strata searches, strata form Bs, and seeing whether or not. And this is important sometimes when it comes to buying a business that's in a strata. So you know what the strata has in terms of rules and complaints they may have against certain businesses and meetings that they have and things like that. Financial statements, court services online. Now, this is pretty good. Anybody know about court services online? It's pretty cool. So it happened one time. Uh, the And what it is a listing of all cases that are happening in BC at once: civil, small claims. Also, you can find criminal, you can find family, all kinds. And you type in the name of the person. For you have a potential tenant, you put it in there and you sign. Oh, they've been sued by previous landlords. So no, that's important. Or if you're a potential tenant and you want to search in and you put in the landlord's name here, and you find, oh, this landlord's suing a whole bunch of people. Maybe they're highly litigious. They like suing people, and it's not a sign of necessarily bad, but it just means that they're in court all the time. I wonder why. So it's a good thing to find out. And sometimes it's not always about money. So I did a search one time, and the landlord had sued the potential tenant because I think they removed some of the equipment out of the restaurant before they're supposed to, and they want it back. And so it's not that they took it and they want the money to replace it. They want the equipment back. So they sued them to return. Doesn't seem like it's a money thing, but it's a compliance thing. It's an indication of how well they listen to rules, right? So it's important.
So for EPSA, how do we get information? There's a this thing we need to provide all those information, or we need to get it by ourselves.
So there is if you have a BCE ID and you have access to the same registry where you access corporate online searches and then you can do that. You can do the search. Yeah, yeah, yeah. There you go. Yeah, you have all the.
It's like a resident this thing they
Yeah.
by those information, or we need to put our So
Quite often it's not something that's regularly supplied to the, you it's just like you search yourself to find out. So normally it does not even get discussed at all. It just, there is a term in the contract, everything you buy, the equipment is going to be something you can sell. But how do you really find out? It's just like a title, right? You title search, you see it. If I do the PPSA search, oh, this equipment, this car, this piece of equipment, it's not, but that doesn't belong. There's money owed on it, and quite often one of the biggest, if businesses have operating lines of credit, they have money from the bank so that they can run the business and draw on it. Quite often they have a PPSA on their equipment, ongoing, including future business, future income, and including accounts receivables, and then also the equipment. So yeah.
What's the turnaround? What's the longest turnaround time for one of these searches?
Oh, you can do it instantly. I can do like
Do you
within
get to-
minutes. Oh yeah, yeah, very quick. Yeah, very quick. And that's one of those standard things I do. Whenever I have a corporate client that's buying some business, I do a corporate and then run their business. Sometimes, there's things you can check. You can do all these checks and you can still miss something. I had a client one time, they're buying a Waves coffee shop. So how they did it, but they stood there and they looked all around. You get this, you get that, you get this, and you get that. Great, everything happened, completed. And then the new buyers started the restaurant. And then one day, people came in and started rolling up their carpet. He said, "What are you doing?" He said, "You didn't pay us to clean the carpet, so we're taking the carpets back." I said, "Carpets? You know what? Because they stood on it and looked everywhere. They didn't look down and they didn't think this is what was involved." So, yeah, this is all interesting stuff, but these things happen. Do they actually own what they're selling, and do they actually include everything that they've said they're including? And just look around. Sometimes people just take pictures. But the pictures without identification, sometimes the equipment can be replaced or swapped and the quantity isn't clear. It's not as good as actually listing everything out and writing down what it is, how many you get, what you know anyways. Okay, sounds good. Answers questions. Yeah. Okay. Yep, go ahead. Oh, hi, James. Yeah. Yeah, serial numbers, equipment. No, but you describe it. You describe it. The front entrance, this, another time was crazy too. Chinese restaurant. They listed everything. They thought they put everything in. But you know what? They forgot. Like half hour before the new buyers, my clients opened the restaurant. They opened the basket where all the chopsticks were. No chopsticks. What the hell? Chinese restaurant just half an hour before opening and no chopsticks. It's just like they look at, then they check the list. They got spoons, they got bowls, they got plates, they got that. Forgot the chopsticks. Oh my god. So they had, but anyways, what do you need to run a business? Like any business, yeah, all business are different, right? So anyways, it's all kinds of stuff. Yeah. Actual thing that happened. Anyways, you guys ever heard of estoppel certificates? Yeah. So just to let you guys know, so you have a landlord with an existing tenant, and somebody wants to buy the business with the tenant inside. So in that situation, if you're the buyer, you're acting for the buyer, how do I know whether or not after the purchase, there's an ongoing dispute between the tenant and the landlord that isn't resolved? So inside some leases, there's a special provision allowing the landlord to go to the tenant, sign this to confirm that there's nothing that the landlord owes to the tenant, and there's no outstanding things that need to be done or fixed or done, so that they can take this over, signed by the tenant, and give it to a new buyer. A new buyer comes in and the tenant goes, "Hey, the landlord owes me money." I said, "No, you signed this estoppel certificate. You cannot come after me now." So some leases have that, and it's very good. It's a protection for your buyer client. Okay. And if you're selling, it's good to be able to show to the new buyers coming through that they have no ongoing dispute with the tenant. Holdbacks for due diligence, that's very common. So while you're checking, it takes time to do these things. Maybe 2 weeks from the city of Vancouver to come up with searches, maybe a week for fire department searches. PPCA is quick. But while you're doing this, all of a sudden completion date's happening and you're not done yet and you don't have the reports. So quite often you need a little bit extra time. So that's quite common to put a holdback so that there's time to do all the due diligence and then release the monies when it's found. What will happen to existing employees? That's important too. You guys, So when you do commercial, sometimes you have to deal with all kinds of laws, not just the security and charge and enforcement, but also dealing with employment law. So there's such a thing as you take over a long-standing employee, if you're as a buyer client, and then later on you fire them. You can be responsible in common law for unfair wages, unfair practices of dismissal based on the time they began their employment until the time that they were fired. So if your client bought halfway through, if they're not just liable for the time in which they were the actual boss, but right from the very beginning when they first started their employment. Some businesses have long-standing employees. So to protect your buyer client, you need to make sure that the seller fires their client. And then the people who are buying, you rehire them, whatever rate you want to do. So it starts the clock from beginning again. So they're not responsible for anything in the past. Okay. Yep. Two questions now.
I have very limited knowledge of existing employees.
Yeah.
The buyer rehire these guys
Yeah.
at the same wage and duties, etc., and be considered a
Brand new one. Exactly.
brand new, or would it be would the buyer be responsible for part of the severance or with the notice?
It's considered brand new, yeah, because you have to make the seller fire all the terminate, hand out ROIs, all of them, so they all know, here's your ROIs, you know that they've all been fired, and you start brand new. So sometimes the buyer doesn't want all of a sudden to take over a business. All employees are gone. So they want to make sure so they can have prior arrangement. We promise to keep the new employees under a new contract, similar wages and rates, similar positions and similar hours, so they don't run off and take off. Because there's a lot of uncertainty. Sometimes seller clients don't want to let their employees know that they're negotiating a new buyer coming along in case of that happens. But of course, put that in the contract, but then have the buyer know what the wages are, what they're paid, and if they're comfortable for it, have that in the contract as well. Yeah.
How do you best protect the, let's say you're representing the buyer?
Yeah.
Seller's obviously not going to tell their employees until subjects are removed.
Yeah.
And the buyer, how do you best protect the buyer so that they can keep the employees?
Yeah.
No seller's going to agree that all this is
No.
they can't do.
Yeah. They can't, for example, they can't promise that, but what they can do is great efforts to encourage the employees to continue staying. So you can put built into the thing is that they will arrange for a meeting between the potential new buyers. They promise that they're going to have the same, they won't be fired. I mean, not they won't be fired. They'll be fired and then retained. They'll be rehired at the same rate. And you put that as a contractual provision. So they're protected. So, for the buyer that doesn't know whether these employees will leave, so they have some prior contact, they have some prior information. But again, it's a seller, if there's enough time between subject removal and completion, there's enough time to work that out. But if it's like subject removal and then all of a sudden you give them a notice and then the next day you have new buyers, that may not be the best. So some time in between. Yeah.
Let's say the buyer takes over and 50% of the employees they
Mm.
the new
Yeah.
You're pretty much out of
Yeah, yeah. You can't control them to that point. Yeah. Yeah. Sometimes like what I done and I put down in contracts, we let of course, after subject removals, we let the new buyers get training. And so they work with the employees and they see how they get along. And so they have some prior exposure to the new buyers. And then hopefully they get along. Yeah. Crystal, you had a question there? Yeah.
Like you got fired, got rehired, who's responsible for the activities?
Yeah.
I will pay you
Yeah.
like to retain your
Yeah, good question. Like usually you don't want a gap, but maybe there's a gap because the business is closed on Friday, opens on Monday. The gap is on the weekend. You can time it sometimes. That good, but quite often you want it to start as soon as one ends, the other one begins. So and then if you time it all right, you did a completion date on the 30th and possession date on the first. Pew, perfect works. But sometimes you can't plan it that well. Oh, the first happens to be a holiday. Okay, the next day. But anyways, you try to do what you can to have no gap. Yeah.
month long, yeah. Who will be responsible?
It'll be entirely the buyer because now they're responsible now. They're the new owners. They have to make those arrangements to make sure they have enough people to run the business. Yeah.
I understand what you say. If like with a long-standing employee,
Yeah. Yeah.
and now it's like,
Yeah. So I think for there's things such as wrongful dismissal. If you dismiss them and they don't have good grounds for it, there's common law in case law as to how much compensation needs to be given to that employee based on how many years they worked. I can't remember exactly the figure. I don't deal with this employment stuff all the time, but it just builds up. The more you work, the more you have entitlement. And so you can ask for that. No, there's common law, which is basic amounts, and I really can't remember how much. But then there's also punitive ones. So if you found out that they was fired without with not a good reason. There's a kind of firing called what's the name for it? Where you change the hours and you give them different shifts at different times, and then all of a sudden you're still paying them the same, but you're changing the circumstances of their employment that they feel like they're fired. And then they quit because they can't do those hours or do those times, and then they can sue the employer for that. So that's all part of it. So your new owner comes in and you kept them from before, you change everything, and then all of a sudden they can say, well, you fired me without really firing me. Yeah, 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 yeah. So there's all these liabilities that can continue. So if you start brand new, you have nothing to demonstrate that you had experience and give them a certain pattern of employment that they come to rely upon. And because it's all brand new, it starts all new, right?
number 9, estoppel.
No, it doesn't apply to that. Because estoppel certificates are between the landlord and the tenant, not the employees of the tenant. Yeah. Makes sense? Yeah. Yeah. Unless they have something against the landlord as well, but you probably doesn't really, that's not what it's for. Yeah. Okay. Sounds good? Okay. Yeah, I will let me just. Oh, yeah, this is quite often. Like, you guys ever heard of a triple net versus a gross lease? You guys heard of that? So I always insist on getting landlord clients to insist on a triple net. For my tenant clients, I want to insist on a gross so that they have set rates. Nothing goes up, nothing goes down. So, this is very important because sometimes you control your base rent, but you make the tenant, for example, responsible for insurance, and then the deductible for the insurance just drives up the premium. All of a sudden, it's double the actual basic rent. These things happen, so it's important to have any potential buyer client to be aware how the rent is paid and how it's calculated. Yeah.
For let's say that your adjustment
Mm,
in August 1st, right?
mm, yeah.
And then uh, let's say the buyer comes in, takes possession, runs the business for 4 months,
Yeah.
and then by the end of in December,
Yeah.
the rent gets consolidated.
Mm.
The additional rent gets consolidated,
Yeah.
and all of a sudden, property taxes went significantly higher,
Yeah.
right?
Yeah.
Because the adjustment period is August 1st, the seller is responsible from January to August.
Yeah.
Good luck trying to find that.
Yeah.
Right. So
Yeah.
we do.
So for those who don't do commercial leases, like the way this kind of rent thing happens is that quite often, starting say January, you don't know what the property tax, because part of triple net is the tenant pays for basic rent that stays the same or is contracted, and then there's a chunk that goes up or down based on expenses. If property taxes go up, you pay higher. Insurance goes up, you pay higher. It goes down, strata fees. So these are all things that are added on top of a basic rent. So it can go up or down and can fluctuate. So quite often what landlords do is say, well, we don't know what next year will be, but we'll base it on this year and a little bit increase and estimate it so that you pay the basic rent fine. And with the triple net part is that they collect a chunk up front. collect. It's almost like when you have pre-authorized payment plans for the city taxes, and some banks do the same thing for loans. They make the client catch up a payment. If they buy in August, they pay 2 months worth of tax collection upfront, and then they keep collecting until the end of the year. They have enough money to pay that tax. Similar to what happens with commercial leases and triple net. They estimate it, they collect it, but if you buy sometime before the taxes are known, then the landlord has collected some money, but they base it on an estimate and we don't know what it really is. So there's a couple of ways to deal with that. And quite often, sometimes just one way is a holdback. You hold back some funds, we're waiting for the final adjustment from the landlord, and there's funds to collect. That's one way to do it. Or you can say to the landlord, look, can you give us some kind of a way in which they can um, uh, do the calculation and be done with it, because the biggest part between buyer seller is you can't really control the landlord. Landlord may still decide if they agree, look, I'm not going to charge you more if it gets more because it belongs to them. That's great. So quite often, as soon as I get a client, I reach out to the landlord. Hey, tell me how you want to deal with adjustments for dealing with it. Is it estimated? We don't have the total amount. Can you do an adjustment? And quite often, landlord, if they have a lawyer representing them, they ask me to hold back funds. If I'm the seller, I hold back funds on the seller waiting for the final adjustment. And there's more, pay it back. Less, you pay back to the client, right? And it moves on like that. Okay. Does it make sense, Ben? Yeah.
So for the legal practice,
Yeah.
what are do for as a realtor?
Yeah.
If we as a buyer,
Yeah.
agent, we
Yeah.
purchase a business,
Yeah.
but the current seller suggests, hey, you can negotiate the rental term with the landlord.
Right.
So it means
Yeah.
we got extra work. We need to
Yes.
negotiate with the landlord,
Right.
and we need to do another offer to lease, right?
Maybe not. No, very good questions. That goes to another question, which I don't think, oh, I missed it. I should be in number 20. Very good question. But the first thing when you check the lease, how much time does your buyer client have left before the lease expires? 2 years left. Well, you put 100,000 in and then you're gone because the landlord exercises unreasonable discretion. Kick you out. So good time at this point is subject to a negotiated new lease or modification of the lease or extension of the lease. So instead of 2 years left, you add another 3 to make it 5 with a 5-year option, or make it 5 with another 5, 10 with a 10, or grid it longer, and you get the rate set up and the basic rent set, so this uncertainty is taken off as well. It's a good opportunity, especially if the term of the lease is not that good. And you negotiate things for your new buyer, and the seller says, "Look, your credit's bad. I don't want to lease it to you." Well, you offer a higher deposit, but then you put it in the modification. The security deposit can be released over time the more and more that the buyer demonstrates good credit and paying the landlord on time. So as they demonstrate, then you can demonstrate yes to release. So you change the deposit amount. Yes, you add more, but then you can reduce it. And that's negotiating points.
That will be in contract purchase business.
Nah, not gonna. No, well, in the offer to lease, right, or the purchase, subject to the purchase.
Or lease only for purchase this part.
Well, that part I don't know.
No.
That part I think you asked for. Can't. Well, I think you can do both. If you do an offer to lease, you can do that as. Huh. Yeah.
What are the works you're planning to do and what's your service charge on that?
Yeah. Yeah.
So we give an offer to lease.
Yeah.
Subject to
Negotiate.
price, and then you guys do the final lease, right?
Yeah, we can do draft it, but you want to get the basic terms, right? Get it. Yeah. 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 Yeah, and then release the seller would want to be released, right? A complete release if it's not in there. It's a good time to get all those things, and depending on how good the buyer is, then you might release the seller. And the seller says, "I'm not selling to you unless I'm released." Well, then you can work together to get something. Yeah. Yeah.
So in that time, we need to request the landlord, hey, we're working on this deal, so
Yep.
we need to pay us as a commission to represent you guys to make the deal happen.
If the landlord, it depends on who. Yeah. 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 Because the landlord may look at well, the tenant's leaving, and they might not be able to find another tenant, and they're getting a little bit worried. And then you bring them a new tenant. because a new tenant's leaving. This is a good opportunity to do that directly with the landlord, right? You just have to watch out for the conflict part because, are you representing a landlord or you're representing the new tenant coming in or the tenant who's leaving, right? So just be aware of those things and then do the best for each one. Yeah. Yeah. But very good question. That should be number 20. I'll revise that. Hi, Rick. Yeah. I don't know. How much time do we have?
It's usually 1 hour, but it's okay.
You guys let me know because I have a few more things. And then that's the thing about questions. The good questions, you lead on another tangent. So I'll go quickly. This one, 13. Oh, yeah, perfect. It was here. So you were ahead of me before this one. Okay, so length of the term, then you renegotiate and you get extended terms. Are there any options to renew? That's important because you only 3 years ending, you want another chance to recoup your buyer's investment. Restrictive covenants is anti-competition things. I just have this one deal with the lady who was running a nail salon in Langley, for example, and the buyer comes in and says, once I buy, I don't want you anywhere in Langley. Wow, really? That sounds pretty strict. But my client wanted to retire anyway, so it's okay. So you negotiate that part. I don't want. Well, how about 5 kilometers? Okay, well, I'll increase the price, and I'll increase the area, and then she got more money, even though she was going to retire anyway, which is good. It's negotiation, right? What are kinds of taxes? We talked about social service tax on equipment, GST on the total price. Capital gains tax on the equipment, withholding tax if you have a foreign seller, seller who's a non-Canadian tax resident. Okay, and then 17 does it allow, it's something else. Well, you can always find leases sometimes registered. When I have clients that allow a lease to be registered, a commercial lease that's greater than 3 years and long, when the tenants leave, everybody forgets to remove it off title, and it's a hassle to remove it. But one thing important about leases, when I act for all my landlord clients, I say right down there, the landlord is not required to register the lease. Because if you do, then there's rights that are given that greater than, and it's hard to actually remove it sometimes as well. And BC leases less than 3 years are automatically enforceable, but anything over those 3 years, unless they're registered. And the reason why I put this is because of this one case that comes up. It's a foreclosing bank that was able to cancel the lease because it wasn't registered on title. Okay, so competing interests, who owes what? If it was registered, then the bank had to deal with them. Okay, so it's just a case about foreclosures. Now, differences between a strata, lease of business within a multi-tenant building, lease run by a cooperative, shopping center lease, all kinds of things, all different types of business situations. There's things about strata fees we watch out for, common area expenses based on percentage of raw square footage. You got to look at that sometimes because I had a bookstore right beside a restaurant, and they split the water usage equally, which is like, why? Because the bookstore doesn't use water, things like that. And then required opening hours for shopping centers, percentage rent. You guys heard of percentage rent? It's a really interesting thing that happens with commercial rent. They look at how much profit you make over the base rent you pay, and they get a percentage of that profit. Interesting thing, but on top of basic and additional rent. So there's all these categories of rent that a landlord can collect. And when you deal with a client who's a franchise, on top of where's that again? On top of basic rent, percentage rent, additional rent, then you get franchise fees, then you get supplier fees, and that is quite a lot. Anyways, other common law schemes issues, demolition clauses are very common nowadays. You have a commercial business, but there's a demolition clause. Quite often, the landlord can just come and just give you notice, and then we're demolishing it because the developer's coming in. So it's important to look at that. And if you try to negotiate the removal, you try to get out if you can. And if you have a modification and they try to slip in a demolition clause, that's something to watch out for too. Because a strategy to deal with the risk if you have a buyer and the landlord insists on a demolition clause is you extend the lease. If it's 2 years left, make it 5. And you say, look, you can only exercise the demolition clause at the option following 5 years. So it's not like you're removing it, but you're extending it. And sometimes landlords are okay with that. Okay. So it's there, they won't remove it. Doesn't mean that's the end of the business. You can still negotiate. Overholding clauses, like maybe the landlord and tenant are still negotiating rent. They haven't figured out. I don't want the landlord doesn't want the tenant to leave. The tenant doesn't want to leave, but then they're still working out. There's quite often a clause inside leases that says the lease rent is automatically a certain percentage, like double, a half, until they've resolved it. So I insist that for my landlord clients because it's good negotiating point. You go to the tenant and says, you better come up with an agreement class or else you pay me more, right? So, and then this thing, guarantee indemnity, personal indemnity. I try to have my buyer client not be a personal guarantor. You try to avoid personal. That's why you have a company, so that you can avoid personal liability. So you do what you can, increase the deposit, do anything but avoid your client being a personal guarantor. And absolute net cleats clauses, that means that the landlord has nothing out of pocket to pay. If you see this clause in the lease, anything that's not categorized in the regular kind of thing, it's going to be additional rent on top. So that's important. Tenant versus landlord repair costs is also important. Who's responsible to repair what? Most people think structural things is a landlord, and the stuff that the people, the equipment, the things that the tenant uses, the tenant. That's the most common one. And if you don't read it specifically, it may vary that. It may be different. So it's important to know. Okay. So right of first refusal to purchase, like quite often, sometimes a landlord, the landlord wants to sell and the tenant wants to buy the building. So you have that clause. Arbitration clauses. Now have dispute. You go to arbitration. Free fixturing periods is something to attract the new buyer to come in. And there's a thing about leasehold improvement and fixtures, because sometimes the tenant puts all this stuff in, and when they leave, they think they can just take it. And then you read the lease, and so anything affixed to the walls and stuff becomes a landlord's. So it's important for your clients to know what the differences are. Okay. And I think we talked about some of the different strategies about if you're representing a buyer, how to increase the chances of the buyer being accepted by the landlord. Consider additional guarantors, more than 1 month secure deposit, a limited indemnity, additional collateral as security for the landlord. And then a letter of intent. When you're discussing this, there's a lot of stuff to discuss, right? Maybe what you have for the seller, make sure that the confidentiality is binding. Everything else you can discuss, but you don't talk to anyone else, so the buyer can't start talking to anyone else about it. If you're acting for the buyer, you want binding terms on the seller not to negotiate with anyone else while you're negotiating. Everything else can be discussed: price, terms, what's included, what's not. But you might want to have these two things out of a letter of intent to make it binding. Okay, non-binding agreement on important contractual terms, that's a general thing. It's not binding, but you should get something in binding to make it binding there. Okay. On due diligence on landlord, check the landlord out and see what they do, what their reputation is, check their things to be. Now, maybe I won't talk about contracts because there's a lot of stuff involved in here, but I do want to have another time we can talk about when you're buying and selling. Share purchase options, because should you buy the assets or you should buy the share, and that includes land. A company owns land, and you know how much savings you can have from both sides, and there's risk and pros and cons, but maybe we'll talk about that at a different time. Yeah, because it involves a lot of stuff dealing with knowing about companies and shares, how to check shares and who owns what. But that's a whole nother ball of wax. But that involves land, and sometimes it's a good deal. And you take a regular purchase contract and I draft it and convert it complete asset into a land sale to a share sale, and then there's pros and cons for both. But that'll see that for another time. Sounds good. But very good question. Thank you. And then anybody, those who's starting to thinking about, doing commercial, get me in and we'll talk more about that stuff. Okay. Sounds good. Thank you, guys. Hi, this is IBC. Thanks for watching my YouTube channel. Please hit like and subscribe if you want more legal content on the emerging trends and news about the law and the legal landscape in BC.